All right, this is cause number 1830854, and sir, you're Juan Sanchez. And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One, I don't believe that subpoena duces tecum was the proper way to try to get information. Duces tecum is an order to get somebody presented to a set hearing. So we didn't have a set hearing, and they were ordered to give it to it at a set time for a hearing. So under the rules that have to do with subpoena duces tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do.
Here's a key legal nugget. If you want discovery in a probation revocation, you go through the DA, not straight to probation. It's like trying to enter through the back door of the courthouse. Sure, you can try, but someone's going to stop you.
Do it would be to make that request with the district for discovery. And then for you, Mr. Nichols, to make those requests, and then I would approve you guys giving whatever records you're requesting within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that, Mr. Nichols let me know that, then we could worry about maybe a motion to compel and whether or not I think those things are or are not. But lab results, the testing, money owed, all those types of things, I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the
judge maybe and quote. I do think it's discoverable. In this case, all allegations on the motion was not raised on the county. So, it's finished correctly. No, they're not in the loss in that kind of probation file. Well, not even part of the allegation. Usually I respond, Your Honor.
We'll let him finish it.
It's in that Wharton County record, so it's from probation. In this instance, I'm involved with getting all that stuff. A lot of it's not my possession. So I have a county office for and things like that. I don't have it. I don't have this for the end of my program. Yeah, not entirely general.
Sure.
So, and Mr. Franklin did make that discovery request beyond something involving which is our advanced.
Right.
So having you can really responsible to it.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible. Let me look at the motion itself. Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations, and there isn't an allegation, then why would you...
This moment right here is crucial. The judge is basically saying, if it's not in the motion to revoke, why are we even talking about it? Classic legal tension. What's formally alleged versus what's contextually relevant for sentencing.
What is your argument that that would be relevant or disruptive?
Your Honor, my client will stay on probation, and the court will take consideration for form of file on probation. His court and everything else. So part of determining the motion to revoke is relevant to look at the form of file on probation, particularly the request to stay on. He's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides he's off probation, and perhaps mitigating any potential.
Okay, I don't disagree. So,
watch how the judge shifts gears into full-on courtroom counseling mode. Translation: stop swinging legal elbows and talk it out like adults. Judges love cooperation, and they have little patience for lawyers turning minor discovery disputes into World War III.
Again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably. The duces tecum is not the way to do it unless it's set for hearing. That's just rules of evidence. So that's not the way we're going to do it.
Was set 2 days and usually set for a hearing, he specified that we ended up leaving him. Didn't call. The judge asked, well, go ahead,
Yeah. I mean, yeah. I don't think on this list that there are. I mean, is there anything that y'all we had an issue with?
That's a long thing. Yeah.
If there's.
Maybe a clarification is, the hospital chronological, which include anything that pertains to the case that happens with prior telephone calls, I generated appointments, reminders, office visits, drug test, anything we generate. Those are chronological completion office, as well as the routine of the jail law. Secretary of case map. Like before, the judge were not listed on the subpoena, as well as the office report through DPS. So, as to those items typically being released that were not listed in the description.
Your Honor, we don't have to. We filed a 3914 request. This is dealt with because we didn't get any of the information related to probation in our 3914. I would also note that the chronological.
Well, and these aren't. The reason you didn't get any of those is because those aren't his. They're theirs. And so they're not. I don't think Mr. Nichols has the ability legally to make probation give them that. I think once we talk it out, though, I think whatever Mr. Nichols, y'all get together, obviously offense report. If y'all have the offense report and you don't even have it, then you need. I mean, that's great. Everybody can get the information in a minimal way. So let's do that. Y'all sit down. I want everything that you have that is. I don't know that there's anything I can think of that would be.
And here's where things heat up. The defense lawyer pushes hard, but the judge isn't having it. This is a classic courtroom dynamic. You could be right on the law and still completely lose the judge with your tone. Emotional intelligence is a legal skill, too.
That's what I'm thinking about, but it's not really attorney's notes. I don't know that would be an issue.
Your Honor, it's not a work product. It's really work product for you. Discoverable and relevant.
That's what I just said. You seem very frustrated, and I'm not sure why. I don't know.
I'm confused why there's pushback at all. It's easier to put us for 3914 discovered when it's constitutionally allowed to file. It's just produced by probation without filing. You got to do it right just before the introduction of discovery. We had to file a motion to tell it.
Well,
that is alarming to me that you have to tell anything in 3914.
This is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on. And the last thing you want to do is talk over me. So I'm sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, offensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's a hearing or a plea or a trial, what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? It exists. And he says no, then let's have a hearing about it. Okay? So y'all get that done.
Notice how the judge brings everything back under control. She lays out the procedure step by step, a reset, discovery through the portal, and a future hearing if needed. This is judicial damage control 101, clean structure after a messy argument.